All right, the last case of the morning will be Carlos PRATTS and Diana Stilson versus Deutsche Bank National Trust.
Deutsche.
All right, you may proceed.
Good morning, Your Honors. May it please the Court. My name is Sherry DeWitt, and I represent the appellants, Ms. Stilson and Carlos PRATTS. This is
Let me ask, how much time do you want for rebuttal?
I'd like 5 minutes, Your Honor. Thank you very much. Appreciate it.
Mr. Witt, was non-compliance with 1.070 raised below?
Yes, I believe it was, Your Honor.
Where?
I believe that it was raised in the motion to set aside the final judgment and to set aside the sale that the trial counsel filed with the court, which is part of the record.
You believe or it was raised?
I'm not 100% certain. I'd have to check.
And you did not assert that that was raised in any of your briefs, correct? In your initial brief or in your filing, correct?
Oh, in my brief, it's raised as an argument.
You didn't cite specifically to the record where it was raised, is that correct? I didn't catch that in your initial filing.
I'm sorry, I'm not really going to be able to answer that question without looking. I don't specifically remember my inclination. My memory is that it was raised, but I could be wrong.
Well, when you sit down, why don't you take a look at that and perhaps see if you can cite us to where in the record that would be.
I will look, Your Honor. Thank you.
And before you go any further, I just want to I've tried to boil it down to your position, and from reviewing the initial brief and what followed after that, my recollection is your client is basically asserting a simple denial of adequate service of process. Is that correct?
No, it's more than a simple denial, Your Honor.
How so?
Well, because they also offered an explanation, alternative explanation as to how the error could have occurred.
Well, but your explanation is that there was another person, I think it was the niece that was present in the household, and the niece was the one who received the service of process. She, of course, unfortunately had some type of disability, some type of impairment. So your position was someone was served, it just wasn't someone who was legally competent to receive the service, correct?
No, we don't know whether anybody was served or not. We don't have any first-hand information about that.
Didn't your client file an affidavit that indicated it was the niece that was served?
That they believed it was the niece that was served. The niece is mentally handicapped and disabled, and mentally disabled, and the testimony was that even if it was she that was served, I think she's 20 years old, she wasn't...
How old do you think Judge Wallace is?
Younger than I am, that's for sure.
You could get it within 20 years?
Yes, I think I probably could get it within 20 years. And
But the process server wasn't able to get this within 20 years, was he?
Well, the process server was able, the process server got her age.
Never addressed the age discrepancy in that argument, and that age discrepancy seems huge. I mean, one's 50, the other's, 20.
Your Honor, my argument is that you never even get there. Because the return of service is deficient on its face. And if a return of service is deficient on its face, service of process must be quashed.
But you made two arguments below and two arguments in your brief. One was that the clear and convincing evidence was that this 20-year-old was served rather than one of the parties. And your second argument is that the process was served improperly and not in compliance with the statute. So, I mean, the questions just asked are one of those two arguments. I mean, we didn't raise the argument about the 50-year-old versus 20-year-old or the wrong person or the niece. I mean, that was raised by, you both below and here. So I think it's a fair question to say, is it reasonable that a process server, is it reasonable for a trial judge to believe that it's more likely the process server was wrong on 3 inches of height versus that the process server was wrong on 30 years of age.
I certainly understand the argument, Your Honor, and that's probably one of the reasons why we didn't go into it in detail. However, having said that, the process server had absolutely no independent recollection of serving these people.
Of course not.
And-
You say that as if, we should be shocked or appalled by that. These people serve, thousands and thousands of people. Of course they don't.
But that's something that they're going to have to say in order to rebut any kind of evidence that my client presents that she wasn't served. Under Corrine, basically the court said that saying that it's the policy as to what they do is not sufficient, and in that case it wasn't sufficient also because the process server had no independent recollection of the service. He couldn't even identify her when he saw her first. He said he'd never seen her before, and then he said, well, of course, except when I served her.
But you're willing to rely upon the notes of the process server to advance your position, which that there was a discrepancy as far as the height of the person, but yet you're going to disregard the description in the notes of the process server as far as the age of the person who served.
I'm saying that it's ambiguous. I'm saying that it's not sufficient enough to specifically overcome my client's denials, number one, and an alternative explanation.
Well, isn't there also circumstantial evidence in the sense of the bankruptcy filing?
The bankruptcy filing is not evidence whatsoever. Under Bedford, which is a Florida Supreme Court case, even if my clients knew about the foreclosure, it does...
Again, that's a different issue. But we're talking about this issue of whether they were, I understand, you're saying it doesn't matter whether they were actually served or not. Perhaps maybe that's what you ought to do, is just to say we abandon, our argument in terms of whether the right person was served or not, and our argument is going to simply be that they didn't comply with the statute in terms of putting the date, time, numbers, and they didn't get that right, and that's our single argument.
We make both arguments, and I'm not going to abandon the second one because
Then
they're...
you're going to have to answer questions.
Because
would the bankruptcy filing not be circumstantial evidence?
Circumstantial evidence of what?
Who got served?
What does that have, I don't understand, bankruptcy...
You're making that argument. I'm not making the argument. You're making the argument.
I'm sorry, Your Honor, I'm not understanding what you're trying to ask me.
Here's what I'm saying. Your clients testified, I was not served. I had no notice, I was not served.
With the foreclosure?
The first time I learned of the foreclosure was the day before the sale.
Yes.
Now, if the judge finds out that the person has signed under oath that they were aware of the foreclosure suit long before they said they were, can't the judge say, well, you know what, I don't believe the person when they said they first learned of this the day before the sale, which means I don't believe the person when he says there was no service.
I understand the question, Your Honor, thank you. First of all, the testimony was unrebutted that my client did not sign what was served in the bank, filed in the bankruptcy court.
Under oath. The trial judge can...
Did not. My client did not. It was an electronic signature. My client testified he never saw what was filed.
Service, electronic signature that said this is being made under oath.
I understand it was filed by his attorney. That's all I can tell you. The unrebutted evidence...
You're missing the whole concept of electronic signatures. If we're going to allow lawyers to get up and make the type of argument that you're making now, then electronic signatures are useless.
Judge Carlin, all I'm saying is I was not the trial attorney. I'm looking at the record. The record clearly reflects, you asked me a question, the record clearly reflects that Carlos PRATTS, who's the only one who filed bankruptcy, Ms. Stilson did not file bankruptcy, so that argument does not apply to her.
Would it support a conclusion by the trial judge that I don't believe Mr. Stilson when he says he first learned of the foreclosure the day before the sale, given that this bankruptcy proceeding had been going on for quite a while? It can be assumed that he was getting copies of pleadings, be assumed that before he put his electronic signature down where he could be convicted of perjury if it was false, that he had actually read it beforehand. Can't the trial judge make those assumptions based on that document?
Well, first of all, if he did, it did not apply to Ms. Stilson. She was not a part of those bankruptcy proceedings, so it could not have applied to her. Secondly, that's not what the court did. What the court did, if you look at the transcript, is the court said, I'm going to grant your motion to quash unless I see that the verified pleading in the bankruptcy contains the foreclosure.
that, you know, I'm tending to believe you when you say you never got service, but if I see that your bankruptcy documents indicate you knew about it, then I'm tending not to believe you. Why couldn't it mean that?
Well, he could, but there are no findings of fact as to that. There's no rationale in the...
You're assuming that the judge's language meant that he was basing the decision on actual knowledge. To me, it suggests that he was determining whether your client was credible or not. And once he got those bankruptcy documents, he decided your client wasn't credible.
But, Your Honor, my client was never served. My client was served by substitute service. So Ms. Stilson was served for him. So that credibility issue would not have come into play because it was clear he was never served. Now, whether or not he knew about it, that's different, but that's not...
He was served, he was just served constructively.
Right, he wasn't personally served. He was served by substitute service, allegedly, on Ms. Stilson. So his credibility...
And arguably the best way to know if you're in a lawsuit and a foreclosure is being served whether personally or constructively. So the judge, you know, it seems to me the judge could find that if this guy filed those bankruptcy documents and signed his signature, electronic or otherwise, and put under oath that he knew it, and even knew the case number, and you know, when the action was pending, that it's an easy jump and a reasonable jump, that he was lying when he said he first learned about it at the sale, and that suggests that he first learned about it when he was constructively served.
As to him, perhaps, but clearly not as to Ms. Stilson.
Well, he couldn't know about it. If he's constructively served, you know, the only way he knows about it is if Stilson tells him. You know, you might want to start making the argument as to whether just simply, regardless of actual knowledge, whether the statute was complied with, and if so, or if not, what the implications of that are.
Well, the statutes weren't complied with. Neither of the statutes were complied with. First of all, 48.0311A, which is the substitute service of process statute, was not complied with. We have an issue with the return of service, and this issue, I will concede, was raised, that the return of service was not facially valid, but the specific factual argument was not. In reading the reemployment case, the Fifth District Court of Appeal reemployment case, the facts there were that initially the return of service did not show when the process server received the summons to be served. Then they amended it and said that they received the summons to be served on a certain date. It turns out that that date that they said they received it was prior to the time that the summons was actually issued. So there was an error in that return of service. In looking at these documents, that same error occurred. The summons was not issued until, I believe it was October 14th, and it says that the summons was received by the process server for service October 6th. So the return of service cannot be valid because it says it received a summons prior to the time that it was issued. Under reestablishment, that in and of itself voids service, and service of process should have been quashed. Now, that factual argument, as far as the timing, is in the record, but it was not made until this very moment. I will concede that.
So you're trying to raise an argument for the first time during oral argument. It wasn't raised below, it wasn't raised in the briefs, you want to raise it at oral argument?
The argument that the return... Partially.
There's a yes, it's a yes or no, and it seems to me the answer is clearly yes. That you said that, and you know, Mr. Witt, you've been practicing, and you're an excellent lawyer. You've been practicing for a number of years. You know that you can't do that.
You and I just acknowledged that it wasn't made until this very point.
And don't make it. Don't make the argument. You know it can't be raised for the first time. It can't be raised for the first time on appeal. It certainly can't be raised for the first time at oral argument. Don't do it then.
The legal argument that it was invalid on its face was made.
That's not good enough. That doesn't cover the entire penumbra of all possibilities in terms of, in effect,
Let me go on, if I might, Your Honor. It's also invalid under 48.0315 because it requires that the first page of the summons served contain the date, time of service, and the ID number and the initials of this process server. The process server acknowledged that he did not do that. He didn't do it. It's a flaw in what he did, service a process.
Did he acknowledge he didn't do it, or did he acknowledge that the 2 copies that you submitted at the hearing did not have it?
No, he acknowledged that he didn't do it. I believe it's on pages 19 and 24 of the transcript, Your Honor.
Because no one ever put into evidence the one that was actually served, correct?
You're right. Nobody put into evidence the one that was actually served, and it's the person's burden who wants to establish service to show that it was properly done.
This is a little different than the typical motion to quash. This is, in essence, you're seeking to declare the judgment was void. So why is the burden at that stage on the plaintiff rather than the defendant?
Because you have to have service of process in order for the court to have jurisdiction. Jurisdiction can be attacked at any point in time, and the standard is always the same, and that is whether or not the statutory requirements have been met.
Well, let me ask you this. If instead of filing, if your client, knew they were served and they got this summons and they filed an answer, they decided it wasn't worth pursuing a motion to quash, even though they figured it'd be successful. They just filed an answer to the complaint. The lawsuit can go on, right? I mean, it's a waivable defect, right?
Oh, it's a waivable defect, not if you file an answer, but if you ask for affirmative relief. In other words, you have to file a counterclaim or ask for some kind of affirmative relief for it to be waived. And they didn't, and even in filing an answer, they wouldn't have. But their testimony was...
They filed an answer, said we admit paragraphs 1 through 5, deny the rest, then they've waived any issue as far as the service of process.
No, they don't.
so they can file an answer, let it go, it goes to final, they lose, they go to a trial. They lose a trial, the judgment enters, your position is that you could then come back and challenge the service of process.
No, they have to raise service of process at the same time they file the answer. They have to raise it.
Or
it's waived, but they can still file an answer and not have it, and not pursue it.
That wasn't the hypothetical that was asked of you.
Right. I'm sorry if I misunderstood. They have to raise it,
The
but...
question is to get to the burden of proof, because here we've had a service of process, and now we've got all of, most of the case law that both sides cite in the brief deal with motions to quash, just whether it should be granted or not. They don't deal with a scenario where there's been a judgment entered and it's a motion to set aside. So if we agree that the summons that was actually served, that no one put in evidence, then it seems to me it's important to know who had the burden of proof. And so you're seeking to set aside the judgment.
Your Honor, you raised...
The burden of proof.
No, you raised the $64,000 problem, and I raised it in my reply brief. And right now, the Kohler case, is it Kohler? Which is a Second District Court of Appeal case. There's basically a split in the DCAs. The 3rd, 4th, and 5th DCA say that the person who wants to invoke the jurisdiction of the court has the burden of proving that each and every one of the elements of the statute were satisfied. Under the 5th DCA, the reemployment case, and the Wold case, and the Walker case, the 5th DCA has taken the position that you have to strictly construe these statutes, and it's the burden of proof on the person who's saying that they got service of process to prove that they did. Now, here's the rub. The case law says that if the return of service is valid on its face, then the presumption is that service was valid, and the burden shifts, in this case to the defendant, to show by clear and convincing evidence that it wasn't. Now, the point comes into under 48.021 whether or not the manner of service, because that's required in the return of service, that you have to say the manner of service. Whether or not the manner of service includes allegations that you complied with either 48.0315 or 48.0311A, substitute service or not. 5th DCA has said, yes, it does require that. 3rd DCA has said it requires it. 4th DCA has said it requires it.
Return of service
2nd
was valid.
DCA...
The return of service was valid on its face, right, in this case?
No, that's exactly what we're arguing, that it was not valid on its face, because it did not show compliance with the statutory requirements. And under all the case law in the 5th DCA, it's not valid on its face, so you don't even get to whether or not my...
The return of service was valid on its face, correct?
No, the return of service was not valid on its face. The return of...
It wasn't challenged by you below or on appeal, right?
Yes, it was. The return of service was challenged on appeal.
It didn't include date, time, numbers, and of service, correct?
Yes, and because it didn't say, for example, that it explained the content of the process to the person that they served it on. Under substitute service 48.0311A, that's a requirement. Under 5th DCA case law, it's a requirement that the return of service, or if not the return of service, then the proof that the plaintiff prove that they complied with those requirements. There was no proof here that those were complied with.
You used it for 20 minutes, I'll give you 2 minutes for rebuttal.
Thank you, Your Honor.
May it please court. My name is Richard Swankin with the firm of Baker Donaldson, and we represent the appellee, Deutsche Bank.
Is the actual service of process even an issue here?
I don't think so. I don't think the court really ever had to reach that, because it's interesting. When I looked at this case, I thought this is a very, very simple case, but it's become very complicated by the way the appellant was arguing it. Basically, they're making what I consider to be two almost mutually exclusive arguments. They're saying, we were never served anything, but even if we were, what we were served was improper because it didn't follow the statutory.
Let's focus on the second one.
Right.
And they're allowed to raise alternative theories. But
Absolutely.
Let's focus on the second one, that the service was invalid.
Now, I'll confess, the court seemed to believe that the argument was that the return of service was valid on its face, because that was the standard that it applied. I'm hearing now today that they challenged the return of service, but I don't believe that argument was made below. I believe what they were challenging was the statutory requirements that would have been on the summons and complaint that were actually served upon them, even though they claimed they weren't served anything. All of the case law that they cite, or vast majority of it, deals with parties that were, yes, someone showed up to my house, they claimed to be a process server, they handed me this piece of paper, but the piece of paper didn't have everything on it that it was supposed to have on it. I'm submitting it to the court can review it and determine that those statutory requirements were not followed. In this particular case, there isn't anything like that. They're trying to create by implication with the copy of the summons that was eventually filed with the court that the two copies were identical. But even the process server acknowledged, I didn't take a Xerox copy with me. I usually put this stuff on both copies, but I acknowledge I didn't put it on this copy, but I can't say with any certainty I didn't put it on that copy. So then you go back to, well, what is the standard of review if you consider that the return of service is valid on its face? Well, the return of service valid on its face, then it becomes clear and convincing, which is what the court applied.
So is his statement that I usually, apparently we don't have it, right?
Right.
So is his statement that I usually do this, but I don't know whether I did it here,
Right.
and I didn't do it in this copy,
Right.
does that make the return of service valid on its face?
I believe the return of service that we're discussing is the one that was actually filed with the court, not the one that was actually served on the. I think we're talking about two different things. So yeah, I mean, if they properly raise the argument that the return of service was invalid on its face, then I think you bring in all of these arguments, and then again it becomes a credibility determination.
This file doesn't have all the proper documentation on it, correct?
I think that's correct, yes.
Okay.
I think he acknowledged that it didn't.
The 2010 statute, it didn't have to have all those as long as they were all on the original one served on the defendant.
Right, but I believe this was served before the 2010 statute
Right.
went into effect.
So then the question is was it proper information, the required information on the one that was served?
Correct.
And that never came in evidence.
Right, that particular document never came into evidence.
And so we have a statement that I normally would put it down.
Right,
On the other side, you have a statement of, we didn't get it at all.
correct.
So who has the burden of proof?
Well, even if it is a preponderance of the evidence, I still think that they have the burden of proof to show, if they're going to make the claim we never got anything, then I think they have the burden to show that they didn't have anything. And then it goes, because you can't prove a negative, basically it goes down to a credibility determination of the two parties.
Well, I guess their argument would be, if you didn't put it on the one you sent back to the court, we can assume you didn't put it on the one that was given to the defendant, and the other evidence, if you would, was pretty sparse on both sides. The other evidence is, I normally put it there.
Right.
All right, so who has the burden of proof and what's the standard? If we're down to now we know how much evidence each side propounded, who had the burden and what do they have to prove?
Well, then I guess, if the argument was made that the return of service was not valid on its face, then they're looking at a preponderance of the evidence between the two parties. I would say that probably the party that served would have the burden to prove that they had put forth service. So, but again, you're talking about the other side, or they had the burden to prove that the service that they served was proper, but they didn't have that document. That document was possessed by, presumably, the defendant or the defendant's niece or wherever it ended up. So I don't know how they could prove it with respect to a document that they no longer had possession of. Getting back to some of the other arguments that were discussed on...
Does it matter whether this is done before or after judgment enters?
I think it does. I think if you're trying to get a judgment reversed, then yes. A normal quashing of service, which many of these cases have to deal with, they have these, what we have in some of these other cases.
Law to support that assertion that it makes a difference and that the burden of proof would be shifted in any way?
Yeah, some of the cases that were cited in the briefs, there was one particular one, and I believe it was the Carones case out of the 4th DCA, in which there was substitute service on a father. The father lived in Florida. The son, there was no dispute that the son did not live in Florida. They substitute service served on the father. I believe it went to judgment, and then that's when they brought up the clear and convincing evidence standard. And in that particular case, which is one of the ones that the appellant cited for the proposition that actual knowledge doesn't take a substitute of the service. In that particular case, the father actually came to the hearing and testified. They served me. I don't live at this address. My son does not live with me. He's never lived at my address, and so they could not they couldn't substitute serve the son on the father. And in that particular case, that was another one of the actual knowledge cases. The court held, well, they've met their burden through clear and convincing evidence that there was no proper service made on the son. By simply coming back and looking at your notes and saying, well, I thought I served them, or they made an appearance in the case showing actual knowledge, that can't substitute for the fact that this service was not made. So that it was admittedly not made. So I think
that was an issue. In that case, then, was whether the person was served or not, as opposed to the language on the summons.
Correct. But that's, again...
Are you aware of any cases where the language on the summons, or whether requirements as far as date, time, and all that, where that issue was litigated after the judgment?
I'm not personally aware of that, Your Honor. Again, I go back to the Vidal and Nert cases out of the 4th DCA, but I think those were, the Nert case clarified the Vidal case, but I believe in that particular case, in those particular cases, they were just trying to quash a service of process. They were not trying to overturn a default judgment. So, again, I think we go back to ultimately the way the court treated it was that it was a clear and convincing evidence standard. I think you go back to the credibility of the witnesses. I do assert that that the court did not rely on actual knowledge for its decision. I think the court got that right, that if you go to the next line after he says, if you can validate this document, then I'm granting your motion. If not, I'm not granting your motion. He says something to the effect of, you can't come into my court and say you never got served, and then, also file a bankruptcy. So I think it was going to a credibility determination. One other thing with respect to the niece that got served and the differentiation between the ages of the ages of the parties and the description of the parties. Now, that was very interesting when they first put Ms. Stilson on the stand. I think it was in rebuttal. They asked her what her niece looked like, and she says, well, she's about my size and shape. And then she caught herself and said, well, but she's actually 3 inches taller than me. So even she acknowledged that the two, presuming this niece actually was served, that the two individuals were so close together that even they believed that they were about the same. So I don't think that there was competent, to the extent that this is a competent substantial evidence standard, I think it really goes back, again, as the court says, to the standard of review. The court treated the standard of proof, treated the standard as clear and convincing evidence, found the two parties that claimed they had not been served not credible, and that is why he denied their motions. If the court has no other questions.
Thank you.
All right, Mr. Witt, were you able to find where in the record 1.07E was raised?
I was able to review the motion that was filed with the arguments, and you're absolutely correct, Your Honor, it was not raised. The court asked about the difference as far as, is there a difference because there was a judgment, and there is no difference. The law is very clear that if the court determines that a default judgment or default is void, it has no discretion but to vacate the judgment or the default. And that's State v. Bailey. That's a first DCA case. The same is in the second DCA with Saharouni.
For those cases where there was no service as opposed to service but allegedly defective summons?
All it says is when service is void. It's not directly this point, but it addresses your issue as to whether or not it's a different standard. And the issue is it doesn't really matter whether it's a default or it's a default judgment.
Well, it's hard to find a void judgment if you can waive it. So, for instance, if you get served and there's a defect on the summons, and you go ahead and file an answer, it's waived, and the court has jurisdiction, and the judgment's valid and all that. It's harder for me to find where, determine whether judgment's void or voidable or valid.
But they didn't file an answer. They didn't waive it. That's not the situation here. That's not even an issue here. And what I want to get to is that
The reason why I question is it different whether the issue is whether the person was served at all, because there's a constitutional requirement of notice and due process, or where there's a defect in the return of service or in the summons or things like that, which have a different purpose than simply notice.
no, that is exactly the purpose. Where there's a statute that says how service of process should be affected, those statutes are to be strictly construed. And there's a line of 4 very direct cases that address this exact point. They're 5th DCA cases. For example, in Schofield, which was just decided in 2012, the process server failed to include the date and time of service and his ID number or initials on any of the documents served under the substitute service 48.0315.
Those are all motion to quash cases.
These are all motion to quash cases, but that's what this
My
is.
question, do you have, are either of you aware of any cases where there's a final judgment and the issue was whether the summons had, incomplete data on it?
None of these cases deal with that, Your Honor.
Okay.
These are all other situations, but I would submit that the law is the same, because either the court has jurisdiction or it doesn't have jurisdiction. And for it to have jurisdiction, the statutes need to be strictly complied with. Now, the issue...
Your time is up. Are any other questions? All right, thank you.
Thank you.